2 centuries ago, a buyer was limited to recover from a seller for breach of an express guarantee for negligence or fraud. After the onset of mass production and distribution, however, those remedies had little value. A guarantee was good, but in the ordinary sales transaction, no one stopped to get a guarantee. Few customers remembered to ask the manager of the supermarket to give a guarantee that the loaf of bread purchased was fit to eat. Further, negligence and fraud have become difficult to prove in a mass production world. How can one prove there's a problem in the production process for a can of soup prepared months earlier? To give buyers protection from economic loss and personal injuries, the concept of warranty liability developed. Warranties are either express or implied and are covered under the UCC. Many courts have still broader protections beyond the UCC contract remedies is required and have created the additional concepts of strict tort liability, often referred to as products liability. We're going to learn about products liability in Chapter 9, which is entitled Product Liability, Allocating Risk and Responsibility. Some governmental agencies are located within a particular executive department and are led by individuals who are chosen and can be removed by the president. These agencies are known as executive agencies. And so you're going to read about some executive agencies in this chapter. There are also independent administrative agencies like the FDA and the CPSC and the NHTSA. And they're not housed within any particular branch of government. And they're considered independent because they are headed by a board of commissioners appointed for a specific term. And the commissioners can be removed early only for reasons that are defined by Congress. The Food and Drug Administration is a national agency of the U.S. Department of Health and Human Services. The FDA is responsible for public health and food safety. The agency requires companies to prove the safety of drugs before they can be marketed, and this includes cosmetics and therapeutic devices. Today, the FDA's jurisdiction extends to additional products, dietary supplements, food additives, blood products, products that emit radiation such as microwaves and cell phones, and since 2009, it also includes tobacco products. Genetically modified plants have changed American agriculture. Scientists use DNA technology to remove genetic material from one plant and insert it into another in order to introduce a desirable trait, and usually it's the tolerance to pesticides or resistance to insects. There are some human health risks with the GM foods, and these include potentially triggering allergic reactions. Also, they can affect the environment, which includes weeds and the ability for the GM crops to become weeds or for wild weeds to become super weeds. Also, insect resistance to crops that contain the biological pesticides and the creation of superbugs, and reduced biodiversity and effects on non-target organisms. And there is a difference in the way that the U.S. views the GM plants in the EU. The U.S. views the GM plants very similar to traditional food, and there's not as much regulation, whereas there's more regulation with the EU, as you will read about in this chapter. There is also a federal agency called the Consumer Product Safety Commission. It was created by the Consumer Product Safety Act of 1972. It's an independent federal agency, and the purpose is to protect consumers from unreasonable risk of injury, illness, or death from unsafe products. The Consumer Product Safety Improvement Act of 2008, and it was also amended in 2011, and it expands the regulatory and enforcement powers of the CPSC and imposes new obligations, including reporting requirements on manufacturers, importers, and retailers. The National Highway Traffic Safety Administration was created in 1970, and its mission is to reduce deaths, injuries, and economic losses resulting from motor vehicle crashes by setting and enforcing safety performance standards, investigating defects, conducting research, and educating the public. A defective product can cause harm to a person, property, or economic interest. For example, the buyer of a truck may be injured when, through a defect, the truck goes out of control and plunges down the side of a hill. Passengers in the truck, bystanders, or the driver of a car hit by the truck may also be injured. The defective truck may cause injury to a total stranger who seeks to rescue one of the victims. Property damage could occur if the buyer's truck careens off the road into a fence or even a house and causes damages. Another driver's car may be injured. The economic interests of the buyer are affected by the discovery that the truck is defective. The defective truck is not as valuable as it would have been if the buyer is required to rent a truck from someone else or loses an opportunity to haul freight for compensation. The fact that the truck was defective also causes commercial loss. Who is liable in a product's liability claim? Today, products liability theory is a common basis for lawsuits when you have unsafe and dangerously defective cars, toys, drugs, and other products that cause injury. However, the early common law allowed few exceptions to the general rule, buyer beware or caveat emptor, most notably for food products. But prior to the 20th century, most people injured by defective products had little recourse. Although breach of warranty claims remedied some aspects of the buyer beware doctrine, the doctrine of privity of contract limited the available plaintiffs to a product's liability claim. Privity of contract is a rule that a buyer could sue only the entity from whom the item was purchased, not anyone further up the chain of commerce, such as a wholesaler or a manufacturer. And actually, until the early part of the 20th century, again, only the parties to a sales contract could recover from each other on a product's liability issues. A seller was liable to the buyer, but the seller was not liable to the others because they were not in privity of contract with the seller. Or in a direct contract relationship with the seller. Buyers could not reach beyond their immediate sales for recovery. The concept of holding manufacturers and not just retailer sellers liable for products defects was developed in the 20th century. There are two tort claims that are used commonly in a product's liability claim. Negligence is one. To win a negligence suit, a plaintiff must establish that the defendant breached his duty of care, creating an unreasonable risk of harm, and that such careless behavior was the proximate cause of the plaintiff's injury. Usually, a company will not be found negligent if it adhered to industry standards or the state of the art with regard to the engineering, selection of materials, production processes, assembly, and marketing of its products. Also, proof of reasonable quality control procedures is usually sufficient to negate a charge of negligence. However, strict products liability claim makes it easier for the plaintiffs to bring a claim because it makes it easier for injured persons to sue and harder for manufacturers who sold defective products to defend themselves. You have to show one who sells any product in a defective condition unreasonably dangerous to the user or consumer or to his property is subject to liability for physical harm, thereby caused to the ultimate user or consumer or to his property. Excuse me. If the seller is engaged in the business of selling such a product and it is expected to and does reach the user or consumer without substantial change in the condition in which it was sold. Punitive damages are also recoverable in many products liability suits. Punitive damages are more than compensatory. Compensatory damages are just to compensate for whatever your actual loss is, whereas punitive damages are designed to punish companies who disregard safety and to create incentives to make safer products and deter similar wrongdoing in the future. In 2005, in response to lawsuits brought against the gun industry, Congress adopted the Protection of Lawful Commerce in Arms Act, and this act offers protection to firearm manufacturers and dealers when their products are used for criminal purposes. There is also a breach of warranty claim under the Uniform Commercial Code, or UCC. And under the UCC, every merchant who sells a product automatically promises that it's fit for its ordinary purpose, even without stating. This is an implied warranty of marketability. A seller's promise that goods are fit for their ordinary purpose can be enforced not only by the purchaser, but by members of her household as well. In some states, the warranty extends even further, protecting not only the purchaser, family, and household, but also any person who may reasonably be expected to use, consume, or be affected by the goods and who is injured as a result of the breach. Privity of contract rule means that an injured party could only sue his immediate seller for breach of contract or warranty, but that requirement is no longer a bar. Today, a buyer can sue retailers, wholesalers, and manufacturers when goods are not as promised. Enjoy reading